human resources issues to IR and HR professionals to enable them to manage their day-to-day HR operations based on IR employment laws while providing guidance in adopting best practices employment principles. So having said that, today we're going to discuss a very important topic on employment, which is employment legalities on cost-cutting measures involving salary, redundancy, and other related issues, presented by our eminent guest speaker, Ms. Tham Li Vyen, a partner with a law firm, Ms. Raja, Darryl Loh. Just to briefly introduce Ms. Tham, her present core practice area is in employment and industrial relations. In the course of her work, she has advised various clients on the management and handling of employment and industrial relations issues, as well as occupational health and safety concerns. Her clientele extends from large multinational corporations to small and medium enterprises. In addition, she also represents clients in claims and appeals before the courts. So, ladies and gentlemen, without further ado, I'd like to present to you Ms. Tham Li Vyen. Thank you very much.
Thanks, Vishnu. Good afternoon, everyone. Brief introduction about myself. I'm Vivian. I am a partner in Raja, Darryl Loh. I practice in the area of employment and industrial relations. So what I'm going to share with you today is legal issues and the law in respect of cost-cutting measures. The primary focus of my session today will be on cost-cutting measures, and I will also explore methods which will be relevant to be taken into consideration when we cost cut, and also the legal aspects of various exercises that we can look at when we are exploring long-term measures such as retrenchment and the alternatives available to retrenchment. Yeah. So no one is spared. COVID-19 has actually hit everyone, and the world was caught off guard. We are currently in the phase called the Recovery Movement Control Order until the 31st of August. So the past 3 months was indeed a game changer for all of us. Yep. And for purposes of this session, I have prepared some slides which I will share with you to bring us through the discussion. So there has been severe impact of COVID and the consequent movement control order, which the government has put in place in an effort to stop the COVID pandemic. No industry is spared. As a result of the MCO, there were several supply chain disruptions. This has caused supply chain disruptions. Businesses are affected in the way because movement and border controls and movements are restricted. Goods cannot come in. There would be problems meeting demands, fulfilling the shipment of orders, and as a consequence, an accumulation of products in the inventory. There is also a decrease of demand because businesses have almost come to a standstill during the past, especially during the first 2 months of the MCO, save and except for essential services. This ultimately results in a decrease in projected revenue, and this may continue. The effect may trickle on for the next coming months, in fact, perhaps till the end of this year. So steps must be taken by business to address the immediate concern, i.e. whether for those who are hard hit, the immediate need to embark on cost-cutting measures in order to ensure sustainability. Downsizing exercises may be one of the issues and one of the means which companies will consider. Apart from downsizing and also cost-cutting measures, the emergence of technology as a way forward, because of the change in business model, has also affected how manpower is managed, resources are handled by various companies. For instance, people may move on to retail businesses. There would be less brick and mortar businesses. Online platforms may be the way forward. And as a result, certain jobs are made redundant. Certain jobs are made redundant, yeah, and there is a need to embark on possible downsizing exercises as well. Change in consumer habits post-MCO would also inevitably result in a financial impact in companies. Consumers may tend to shop lesser, so certain sectors would be affected. For instance, retail industries, they may be affected in the change in consumer habits. Consumers may be more, uh, may be more, they may be slow to spend on non-essential items, but they will only channel the spending to essential items. And this will affect certain industries who would have to take steps to address the immediate drop in revenue as a consequence, and also the reduced demand in their products. So in order to do this, the first thing that we need to consider before we even embark on the common cost-cutting measures like salary reduction, no pay leave, and also retrenchment exercises, we need to consider whether or not a company has embarked or they have applied to participate in the wage subsidy program. If there are certain restrictions in place, if an employer has applied and participated in the wage subsidy program. So just a brief recap, in the wage subsidy program is a program which is implemented by the government under the pre-Hatim economics package as well as the most recent Penjana economic package. So this is for a period of 3 months, and more recently it was extended for a further 3 months, subject to meeting certain criteria. Companies who are eligible for it are companies who have been in operations before January 2020, and employees who are eligible are those who earn 4,000 ringgit and below, and they must have contributed to the EIS. One of the main reasons why employees, the cap starts at 4,000 ringgit and below is because the government wishes to protect those who are in the B40 group, who are seen as the more vulnerable group. So if an employer has participated in the wage subsidy program, there is a restriction against retrenching those employees who are part of the program for a period of 6 months. There will be no retrenchment for the first 3 months, no pay cut. However, the most recent enhanced wage subsidy program under the Penjana package has allowed allowed some degree of flexibility. For instance, it could be, for instance, in the tourism industry or in sectors which are not allowed to operate during the RMCO, the restriction against placing employees on unpaid leave are somewhat relaxed. So there are certain exceptions, but the general rule is before embarking on any cost-cutting exercise or even downsizing exercise, ask yourself whether there is any application to participate in the wage subsidy program, and if yes, who are the employees who are involved, who are entitled, who are subject to the protection under that program. So in terms of cost-cutting measures, there are immediate measures which most companies would want to take, which is the most obvious is immediate cut in operational costs. And how this is achieved is this could be achieved in several ways. For instance, through renegotiation of remuneration packages. Um, an example of this is where we adapt to new normals. Uh, Most people tend to work from home. There are majority of companies who have not fully gone back to office in full force. Majority of them are still working on a rotational basis, or even some of them are working from home from full. So there may be avenue to consider what are the types of allowances which are tied on to the need to, which are given to the employees when they go to work. For instance, there is an avenue to consider the renegotiating of the provision of transport allowance, yeah, or parking allowance, because now that employees are working from home due to the new normal, there is really no need to for them to incur these expenses. So this is an aspect of the remuneration package which could be considered as to be renegotiated or restructured. Another example would be contractual bonuses. Yeah. So this could be renegotiated by way of maybe a deferment or reduction or even a suspension of payment of these contractual bonuses. Yeah. And thirdly, an example which I could think of is maybe certain companies will exercise their discretion to make additional contributions for EPF. So if an employer has in the past been generous and gave enhanced EPF contributions, now that times have changed, so there is a possibility for the employer to consider renegotiating the additional EPF contribution. There are various creative ways to renegotiate the remuneration package. So because the main aim of this whole cost-cutting measures is to ensure that it's a win-win situation for the parties. It is a collaborative effort to make sure that the employer is able to keep employees in their jobs. And for the employees, they have the benefit of remaining in their jobs during these trying times. So it is a collaborative effort between all parties. And another form, so those are the contractual obligations, contractual payments, which can be renegotiated. Another category of uh, overhead expenses, which could be looked into, are discretionary payments, such as bonuses and increments. Unless otherwise provided in the employment contract, then the company may have the discretion to freeze bonuses and increments. That could be something that could be looked into, unless it is stated otherwise in terms of the contract or in the terms of the collective agreement. And last and thirdly, the most common measure which most employers have embarked on is a salary reduction exercise. Salary reduction is common. Most companies adopt a tiered approach, which it should not be done with the intention to cause severe hardship on the employees. Therefore, it's quite important when, as the employer, when you embark on a salary reduction exercise, look into a tiered approach where the reduction increases according to the pay scale. So that way, those who are earning lesser would be least affected, but those who are on the higher end of the pay scale would would take a higher percentage of cut. The key is to ensure fairness to all employees, and it should be, as far as possible, done across the board. One other thing which you may wish to consider as part of your salary reduction exercise is also to look into reducing the number of working hours commensurate with the salary reduction. That is an aspect that companies can look into, particularly for industries who are affected by a reduced demand. There may be no need for a production line to, for instance, run for 5 days in a row. So consider a salary reduction and possibly a reduction in working hours, because that could assist you in reducing the operational costs as well. Because as a result of a reduction in work for 1 day, for instance, operational costs are reduced as a whole. Lastly, in terms of industries which are severely affected, where there's no businesses at all, examples would be tourism industries, hotels. You could consider a temporary shutdown, and in this instance, you need to engage your employees and get them to understand, get them to buy in to a temporary shutdown, which entails them exhausting their annual leave entitlement, and thereafter, maybe for them to go on unpaid leave or a 50% pay cut, for instance. In short, the cost-cutting measure which an employer will consider will actually really depends on the needs of the industry, the impact of COVID, and also the economic downturn as a result on the business, and of course your overall overheads. So before embarking on these measures, it is very important to conduct a cost benefits analysis to make sure that if these measures are challenged in court, there is evidence to show that, look, I've done all this cost benefit analysis, and this is why I'm embarking on the measure which I'm embarking on, because it is the best way forward for all parties involved. So those are the examples of cost-cutting measures which a company can look into. As far as the law is concerned, it's quite clear. When we are talking about restructuring contractual obligations, reducing salaries, or even putting employees on no pay leave, requesting them to take annual leave, for instance, it can only be done with consent of an employee. It cannot be forced. It cannot be done unilaterally. If it is done unilaterally, there are risks associated to it, and there is exposure to the company. There would be repercussions. So it is very important, to engage the relevant stakeholders if there's a union concern. First thing is look at the terms of your collective agreement. What are your obligations under the collective agreement? A very common term under the CA would be, company would have to engage in, before embarking on any measures, engage in discussions with union representatives to get their buy-in, to maybe vary the term in the CA. For instance, an example would be, the CA may contain a term which requires the company to pay bonuses annually. It's a guaranteed bonus. Engage the union and see, and try to come to a win-win situation and see whether they are open to other avenues. For instance, you can agree to defer, or suspend altogether, or maybe even pay a reduced contractual bonus for that particular year. If the union does not agree, then unfortunately the terms of the CA is binding on the company. And if the obligations are not met, there is a risk of a non-compliance complaint to the industrial court. If such complaint is brought, we will then have to go to court. The burden is on the company to then justify why it is not complied with. The test is special circumstances. The company must show that there are special circumstances for the court to vary or even set aside that specific term of the CA for the specific period. So it is very important, as far as unions are concerned, engage the union representatives as early as possible, because negotiations take time, and engage them as early as possible so that you know what you're in for before you embark on any cost-cutting exercises. As far as the treatment of individual non-union employees are concerned, it's no different from how they approach to obtain consent with the union. It's like you need to speak to the employees, get their buy-in to those cost-cutting measures. If they do not consent, if the company proceeds to embark on those measures unilaterally, there is a risk of a claim for constructive dismissal. Yeah, there is always this risk if it is done unilaterally. So it is very important. How do we approach this? Advance notice has to be given to all individuals who are affected. For instance, if we are talking about a pay cut, advance notice for about a month needs to be given, because employees will be inevitably affected by it. They need to plan. They need time to plan the finances. They need time to take other alternative measures to cater to the reduction of salary as a result. So give them ample notice. Do not approach these individuals or even the unions last minute, because if that is done, it could be held against the company. It could be viewed by the court as not being bona fide. It could be viewed as an act of victimization. Be as open as possible. You need to have your facts with you. Explain the actual situation at hand and why steps needs to be done. If emphasis, to my mind, needs to be given to the employees, that this is really a much needed measure in this trying situation, because we would want to avoid retrenchment exercises or even termination of employment or a complete closure of business as a result. So try to get their buy-in and emphasize to them that this is a collective effort to be taken. It is a collaboration, and it is not an attempt to create conflict amongst all parties. It's a concerted effort. So when an announcement is made to the employees, consider doing it by way of a town hall. Address any queries which the employees have. And if there are further queries, be open, arrange for individual engagement sessions with the HR department and also perhaps the immediate supervisor if need be, for them to address for you to address their concerns and for them to pose any questions which they have before in relation to this exercise. So in short, consent is paramount. If you do not get consent from the employees, it amounts to a unilateral variation of the terms of the collective agreement or of the terms of the employment contract. So if you don't comply with it, if you do it unilaterally, you then have breached the terms of the CA, which may result in a non-compliance complaint before the industrial court, or it may result in a breach in the terms of the employment contract, which will result in a possible claim for constructive dismissal. So it needs to be managed delicately as business owners and people who are dealing with industrial relations is something which need to be shared with the employees transparently as early as possible before action is taken. Of course, for certain businesses, even if cost-cutting measures are embarked on, this may not be enough. It may come to a point where downsizing or right-sizing exercises would have to be taken. A downsizing exercise would more commonly result in a reduction in the number of employees because of a decrease in manpower needs due to financial reasons. Whereas right-sizing in the context of COVID-19 and the MCO may also result in a decrease in the number of employees because of the change in business model. Like the example I've given just now, there may be a change from brick and mortar businesses, no longer have shop fronts, to online business models. So you may not need that many promoters in your shops. As a result of that, employees would have to be, your workforce needs to be reduced, and that would be part of your right-sizing exercise. So there are several ways to achieve this, and the steps to be taken, the methods to be taken, which is via a retrenchment exercise or a voluntary separation scheme or a mutual separation scheme, very much depends on the situation at hand, the number of employees involved, and the categories of employees involved as well. And more importantly, the reasons why that the services of that particular employee is not required. So in terms of legalities involving retrenchment, the first consideration that comes into play would be compliance with the last in, first out principle, or in short, LIFO. LIFO means priority of engagement needs to be given to employees who have stayed on the longest in service. This is only applicable if there are several employees in a certain category. For instance, if you have 4 salesmen, the salesman that has been with you for the longest will automatically get priority of retrenchment. But it does not mean that you cannot retrench this salesman. You would still have, the courts recognize that in a retrenchment exercise, a company still has the prerogative, the discretion to decide which employee is required and which employee is not. So in instances where you need to depart from the last in, first out principle, an objective criteria must be looked at, as the court will look at whether or not that employee was, a more junior employee was retained in favor of a more senior employee based on the objective selection criteria. It could be a situation where the employee's skill sets are more suited towards the job, or the employee has certain experience which is more suitable for the job at hand. There are reported decisions. I will share with you a reported decision in the industrial court involving a company that was in the oil and gas industry. So in that case, there was a retrenchment exercise. The employees involved were those who work offshore. So this particular employee who was quite old, he was retrenched, although he was the longest serving employee. So the argument was there was no compliance with the last in first out principle, and he filed a claim for unfair dismissal in the industrial court. When deciding the case, the industrial court found that the dismissal was fair because there was justification for the company to depart from LIFO. In that instance, the court's decision was based on the fact that it was a service where they had to work offshore and they had to climb up to very, very high platforms, and the employee concerned was not really in good health, and there would be risk if he is performing jobs that requires him to climb up high areas and as well as work offshore for extended periods of time. And in addition to that, there was also a skill set issue where the more junior employee had a better skill set compared to him. So in that situation, the court found that there is justification to depart from LIFO. Apart from the last in first out principle, there are also certain considerations. For instance, if that are set out in the Code of Conduct for Industrial Harmony, the code serves as a guideline, and companies are encouraged to comply with the provisions of the code because it will put you in a better in a better position when defending a claim. For instance, employees who are hired on fixed-term contracts should be considered for retrenchment first instead of permanent employees. Foreigners, non-citizen employees should be retrenched first before citizen employees. So these are things which the court will consider. And in addition to that, the code also sets out the other various steps which the company should look into before embarking on a retrenchment exercise. It was always the emphasis that retrenchment should always be the last resort. So pay cuts should be looked into, freezing of OT, freezing of hiring, reduction in working hours as means to save cost in order to avoid retrenchment. So that are things which an organization should look at before we proceed to retrench. And in terms of payouts, severance payments, the obligation to make payment of severance payment would really depend on whether an employee is someone within the ambit of the Employment Act or otherwise. If someone is under the ambit of the Employment Act, of course, there are statutory formulas which the company has to comply with in computing the payout. There is a mandatory obligation to make severance payment to EA employees. As far as non-EA employees are concerned, their entitlement to severance payment would be as per the handbook or the employment contract. However, most employers exercise their discretion to make payment because they recognize the approach taken by the industrial court, where the industrial court has always decided that an employee who has lost his job due to no fault of his own as a result of a reorganization of business should be given some form of compensation for the years of service. So, which is why the companies recognize this and they would try to exercise their discretion to make severance payouts to the employees who are retrenched, even though they do not fall under the scope of the Employment Act. So that is as far as retrenchment is concerned. And of course, more importantly, it is very important to show that the retrenchment is genuine it cannot be done with the aim of getting rid of the employee, to victimize the employee. There has to be sound reasons, and if there are no sound reasons to embark on the exercise, it will be subject to challenge in court. There may be a risk of it being considered unfair dismissal. The other common downsizing method or right sizing method which the companies look into is a voluntary separation scheme. So what essentially the voluntary separation scheme is different from a mutual separation scheme. A mutual separation scheme is a scheme where an employer and an employee specifically negotiates for mutual release from the obligations of the employment contract, mutual termination of the employment contract on an agreed date. For a mutual separation scheme, it is, to my mind, it is more viable to embark on this when there are a smaller number of employees concerned, when it is a targeted exercise for a specific group of employees which is not required, or specific individuals whose services are no longer required due to downsizing or right sizing. The terms would be as agreed between the parties, and it must be done voluntarily. It is a specifically negotiated package, like what I've mentioned just now. Therefore, the severance payment under mutual separation schemes are commonly higher compared to retrenchment exercises. So that is as far as a mutual separation scheme is concerned. It's where it's jointly negotiated between the parties, terms are agreed upon as per agreement. In comparison, a VSS is an exercise which is commonly adopted by companies who have to let go of a large number of employees. This is a scheme which is open to employees who are invited to apply. The key is employees who are interested are invited to apply for the VSS, and the employer would have the discretion to pick and choose which employee they wish to retain. And in that case, the application for VSS will be rejected, and employees who the company wishes to let go, they have the discretion to accept the application. So that is how a voluntary separation scheme is different from a mutual separation scheme. And more often than not, a VSS could always be a precursor to a retrenchment exercise. In fact, it is stated in the Code of Conduct for Industrial Harmony that certain schemes such as a VSS should be considered before a retrenchment exercise is embarked on. There are certain notification requirements when embarking on cost-cutting measures. If you are going on a salary reduction exercise or a retrenchment exercise, VSS or temporary layoff, there is an obligation to notify the nearest labor department by way of submission of a PK form. There are 3 parts to the PK form which needs to be submitted depending on the exercise which is embarked on. So in all 4 situations, the first set of forms needs to go in 30 days before the date of the intended exercise. And then when it comes to retrenchment and VSS, there is also a need to submit certain notifications 14 days after the exercise and 30 days after the exercise. So just bear in mind, when you embark on these 4 exercises, there is a need to notify the nearest labor department Otherwise, you will be subject to a fine of 10,000 ringgit if you are found guilty. And this is certain, and this is a statutory requirement which we need to be always mindful of when embarking on all these exercises. So that brings me to the end of my session. In summary, all these cost-cutting measures such as salary reduction, negotiation of employment packages, and needs to be uh, needs to be consented to by the employees. Therefore, it's quite important for open and transparent communication to be given to employees, notify them as early as possible before embarking on this exercise. If you proceed unilaterally, there are risks of action from employees for constructive dismissal. There may be an exposure for non-compliance complaint if there are unions involved. So be mindful of all these things, and more importantly, whether or not there are restrictions in place if you have signed up for a the wage subsidy program. There is a 6-month restriction on measures to be taken. And when it comes to downsizing and right sizing, if the initial cost cutting measures is not sufficient to help the business, when you have to embark on a downsizing or right sizing exercise, there are several alternatives that could be looked into depending on your needs of the organization, the number of employees involved, and the reasons for downsizing and right sizing exercise. Balance all your requirements, cost benefit analysis, and you would be able to gauge which is the best way forward. So that brings me to the end of my session. If you have any questions, just feel free to drop your questions in the Q&A, in the chat box, and we'll take it from there. Okay, I've got a query on the requirements for PK form on whether or not it is only for EA employees or non-EA employees. To answer your question, the obligation to submit the PK form applies for all employees, EA or non-EA. And you need to submit that 30 days before the intended exercise. Yep. As far as the fine is concerned, to answer your question on whether or not the fine is per company on the offense or whether it's 10,000 ringgit per employee, the answer would be yes, the 10,000 fine is on a per company basis, not per employee basis. Okay, in respect of the query on utilization of annual leave, I've got a very interesting question. The question is, can encouraging employees to utilize annual leave during the second MCO be considered as a breach of employment contract because it is only encouraging the employees but not forced to? The answer to that is it all boils down to consent. The law in respect of annual leave is intended for an employee as for them to embark on their leisure activities at their own time. So no, an employee cannot be forced to go on annual leave, but encouraging the employees, broaching the idea with the employees is not an issue, provided that there is no form of coercion. Because if an employee is forced to do that, and if the consent is not voluntary, that may be there may be a risk of the employee turning back and say, "I'm forced to do that," um, and it's done against my wishes. Yep. So yes, you're right in the sense that it's important when speaking to the employees, tell them, encourage them that it is a collaborative effort. We need to work together as a team to move forward. This is a win-win situation for everyone. So do consider utilizing your annual leave. In fact, this is uh, a measure which an employer could consider because it would help improve productivity when things return to normal. Yeah. If annual leave is taken during the second MCO, productivity could increase during the next half of the year when we are back in full force. Mm. On the issue of reduction of work hours with reduced salary, of course, there should always be uh, there should always be uniformity, consistency across the board. However, there are instances where there, there are instances where there is justification to only implement this across certain categories. You would need to look at the specific uh, scenario at hand to see whether the reduction of working hours with reduced salary to certain categories of employees is justifiable. If the company is not able to justify that, then that amounts to a breach of the terms of the employment contract if the employees do not agree to it. And in terms of the guidance to calculation of pay cut, it really depends. Yeah. If you reduce the working hours and reduction of salary, of course, it must be commensurate with the number of hours that is reduced. It has to balance out lah, right? Um, on whether salary reduction can only be applied. So that brings me to my next question, to the next question on whether salary reduction can be applied only to selected staff, i.e. those with higher salary. The answer would be yes, but a rule of thumb is try to try not to try not to place undue burden on employees with lesser with, on the lower end of the pay scale. Adopt a tiered approach. Yep. So maybe for those who are earning lesser, maybe a lesser percentage instead of 30% across the board, for instance. There are, of course, certain companies who only impose pay cuts for now to senior management. That could be done as well. So long as a tiered approach is done across the board, not a problem. Mm. Back to the question on submission of PK form. Yes, sir. You would need, if the plan is to pay salary in lieu of notice, the question is whether you can pay salary in lieu of notice instead of serving, whether you can pay salary in lieu of notice to be in compliance with the PK form. I think the important thing to bear in mind is decide on your last date of employment. Yeah. When is your retrenchment date? And then work backwards. If the intention is to pay off the employee and no without the need to serve notice, then the PK form has to be submitted 30 days before the employee's last day. So it cannot be uh, if you submit the PK form on the immediate last day itself, there would be a risk of fine from the authorities. There is a query on non-confirmation of probationers as part of cost-cutting measures and whether there's any impact. Well, in terms of probationers, the law is that probationers have rights as well. Yeah, they have the same rights as permanent employees. So when we are deciding not to confirm a probationer because of cost-cutting measures, the burden is on the company to show that there is justification not to confirm them. If you are not able to show justification, then there is a risk of a claim for unfair dismissal. The next question is there an obligation to submit the PK form if the salary reduction has been consented to by the employee? Yes, you would still need to submit the PK form if there is a requirement. First things first, to recap, you need to get consent from the employee. And if the employee consents, then you submit the PK form. PK form is to be submitted 30 days before. So consent from the employee does not mean that you do away with the requirement to submit that PK form. There may be instances where salary reduction exercise is embarked on as part of cost-cutting measure. There is a query received on whether there is any issue if bonus is paid to certain employees as part of their retention program because there are still projects running until year end. This may be a bit tricky because bonuses, although discretionary, will need to be looked at as a whole. Because in that scenario at hand, the company has already embarked on cost-cutting measures. They have embarked on a salary reduction exercise. So to then pay bonus to selected group of employees, it would look like the employees who do not receive bonus would be victimized. There would be a problem justifying fairness across the board because there would be victimization in place. If indeed bonus is declared, that would presuppose that a payout would be to all employees who are eligible and not to selected staff only. Yep. Submission of PK form. So the question is whether or not PK form has to be submitted regardless of number of employees. There is a reporting requirement. you need to submit it to the Labour Department each and every time an exercise is embarked on, regardless on the number of employees involved. So I guess I have addressed most queries, all of the queries which have been posed. Are there any additional queries? Oh, I've got a new question. The question is there any need to submit the PK form if the pay cut is only for a certain period of time, for instance, 3 months? The answer is yes, regardless of the duration of the pay cut, you cannot run away from the obligation to submit the PK form.
Okay, I think we more or less have covered so many issues. Thank you very much, Ms. Tam. Hope you all enjoyed the session. This is just one of the many sessions yet to come. And we really appreciate your attendance today. And thank you very much to Ms. Tam and the IR Law technical team for setting this up. I hope you all have a great day and a great week ahead. Thank you, goodbye, and see you again.
Thanks everyone for your time. Just let us know if you have any further queries which you need us to address. Otherwise, thanks for your time, and I hope that this session was able to provide some form of guidance as to what to be looked into and how we could restructure a compensation package for employees, and how cost-cutting measures and retrenchment exercises when downsizing and right-sizing exercises are embarked on.
All right, thank you, ladies and gentlemen. We will email you the feedback forms and stay tuned for the next webinar. All right, thank you, goodbye.
Bye.
Bye.